Good afternoon. Today's lecture talk is going to be about the horizontal effect of customary international law. And particularly, I'm going to be looking at the recent decision of the Canadian Supreme Court in Nevsun versus Arraya, which was given on the 28th of February this year. Customary international law and horizontal effect. I mean, you think of customary international law, it's something to do with the regulation of states against each other. What's it got to do with private parties? Well, through the Alien Tort Statute in the United States and its revival in 1979, in the case of Arraya, we've seen quite a development about how customary international law can affect private parties, and it can be the subject of effectively a new tort. In the States, the Alien Tort Statute is pretty well on its way out. That's the result of decisions of the Supreme Court in Kiobel in 2013 and in Jesna in 2018. And the Supreme Court actually asked the Attorney General at the beginning of this year, do you want us to have another look at the Alien Tort Statute, in particular in connection with two cases being brought currently, one against Cargill, one against Nestle. Do you want us to have another look about this? I don't know what the Attorney General's replied, but it looks as if they're trying to pretty well kill off the scope of the Alien Tort Statute. But customary international law has reared its head as a cause of action in Canada. And this is what the case of Nevsun and Arraya is all about. You've got allegations of forced labour being brought in a claim by three workers who are former workers in inverted commas, as we'll see, at the Bisha gold mine in Eritrea. Now, this is a gold mine in which there is a Bermudan subsidiary of a Canadian mining company, Nevsun. So it's the subsidiary of Nevsun, holds a 60% share in this company, which is operating the mine. The rest is held by the Eritrean state. And it's the Eritrean state who actually engages the contractors who run this mine. And the allegations say that this mine is run on slave labor. Young men who have been forced to do military service for 2 years, and at the end of the military service, they're told, you're not going home, mate, you're going to work for nothing in the Bisha gold mine. Now, the claims have been made against the Canadian parent company in tort, conventional tort, and also claims based on violating four specific norms of prohibitions of customary international law. These are aiding and abetting claims, aiding and abetting either the use of forced labor or slavery, torture, cruel, inhuman or degrading treatment, and crimes against humanity. Four prohibitions of international law. And these are forming the basis of a claim by one private party in a national court against another private party, hence the term horizontal effect. All right, next slide. You never quite do this, so we scroll down. On the 28th of February 2020, after 13 months wait from the actual hearing back in January 2019, the Supreme Court of Canada gave its decision. It would not strike out the CIL claims. That's a 5-4 majority. It was not plain and obvious that those claims would fail. And then by 7-2, a much bigger majority, decided not to strike out all the claims, including the tort claims, on the grounds of the Act of State doctrine. So we're just going to look at the decision as regards the customary international law claims, although I think the decision not to strike out claims on the grounds of Act of State is also extremely significant from the point of view of transnational litigation based on human rights violations by um, multinational companies, whether they're being brought in tort, conventional tort, or whether they're being brought on the basis of this rather strange newfangled tort, violations of customary international law. The majority based their decision that there was a plausible claim for an action based on violation of CIL norms on a case called Crown versus Hape, a Supreme Court of Canada decision, which looks at the way in which the norms of customary international law enter the domestic law of Canada, and this happens by direct incorporation unless there's something contrary in Canadian legislation to prevent that. Surprisingly, the majority didn't really look at the large amount of alien tort statute jurisprudence on this issue about whether there could be an action based on CIL. Instead, it looked at primarily academic commentaries, and the one which found favour with it was that of Professor Coe. He observed that non-state actors, like corporations, can be held responsible for violations of international criminal law, and therefore it would not make sense to argue that international law may impose criminal liability on corporations, but not civil liability. Now, there's a whole lot we could unpack in that, and a close look at the the majority and the minority decisions in the ATS case in New York, the Second Circuit decision in 2010 in Kyogo, would make for some interesting reading on that. I'm not going to do that today, although I may come back to that. And the majority then went on to say, look, the public nature and importance of the violation of these rights required a different and stronger response than typical tort claims. That's dealing with the argument that doesn't these sort of actions based on CIL, isn't this just a duplication of what you can get through an ordinary tort claim for trespass to the person, for example? For the purposes of the strikeout application, it was enough to conclude that the breaches of customary international law, in particular, these were jus cogens, mandatory norms which applied even to states who were objectors, that these breaches might well apply to Nevsun. So what now? Now this is not a finding that there is an action based on CIL. It is that it's not plainly obvious that there isn't. It's up to the trial judge now to decide whether there is or not. Assuming it gets to trial, in many of these cases, once you get a finding like this, you will probably end up with a settlement, but you may well go to trial. So let's assume that the trial judge goes ahead and finds there is an action based on customary international law, either directly or through the creation of 4 new nominate torts for violations of those particular norms of customary international law. And let's also assume that those norms affect corporations as well as natural persons, something which has been hotly contested in the US district courts in ATS alien tort statute cases. So what would this new tort look like? In most cases, the violation by the corporate defendant is going to be aiding and abetting a jus cogens norm of international law. Aiding and abetting forced labour, crimes against humanity, could be aiding and abetting war crimes, could be aiding and abetting genocide, aiding and abetting torture. what's the nature of an aiding and abetting under international criminal law, which is the source for these potential civil claims for violations of international criminal law? That's effectively how we've got the basis of something which has horizontal effect. International criminal law affects individual people, it's not just states, and moreover, it's not just state actors who can be affected by international criminal law. Various German industrialists found themselves in the dock at Nuremberg for aiding and abetting war crimes or crimes against humanity, and at least one of them ended up being hanged for it. In the case of Prosecutor versus Furunzija, which is a case from the mid-90s, the International Tribunal for the former Yugoslavia, we get a definition which has been taken up by the American courts. Practical assistance, encouragement, or moral support which has a substantial effect on the perpetration of the crime. So that's your actus reus. And I'll come back to that a little bit later. It may be quite significant what is meant by practical assistance having a substantial effect on the perpetration of the crime. Then there's mens rea. Does this practical assistance have to be given in the knowledge that an international crime is going to be committed by state agents? Or is it necessary that you share the purpose of the people who are actually going to go ahead and commit the violation of one of these prohibitive norms of international law? Again, something of controversy in the ATS cases in the States. And the most recent thing which we've got is again from the appeals chamber of the International Tribunal for the former Yugoslavia in Prosecutor versus Sinovic, in which the appeals chamber says specific direction is not an element of aiding and abetting liability. So knowing assistance would suffice for the mens rea element. So that sketches out the elements of this tort of aiding and abetting violations of customary international law. Why bother with suing in customary international law? What's wrong with ordinary tort? One thing is that ordinary tort, you would be suing the sort of aiding and abetting, you would be suing them as a joint tortfeasor. They've got to have effectively shared the purpose of the state agents who are committing the primary wrong, the state agents who are compelling young men to work as slaves in the Bisha mine in Nevsun and Arraya. That's going to be very difficult to show if you purposive assistance is required, but easier if it's knowing assistance, in which case you've got a better chance of finding liability on the part of the company who's alleged to have been complicit in this wrong which has been committed against the claimants. There's also the greater publicity value of the tort. This is really, really serious. This is international law which has been violated. It's a really bad thing you've been doing. This is basically law as publicity. There's a much greater moral censure in finding somebody liable for aiding and abetting a violation of international law than just being a joint tortfeasor for a bit of trespass to the person. So it goes back to the trial judge. Are the Eritrean claimants going to win? And I can see two problems here. And one of the problems is this actus reus. Now, the position of the Nevsun subsidiary parallels that of various banks that were sued in the US case in New York in the South African apartheid litigation. They had provided loans to the South African government. They'd purchased South African Defence Forces bonds. That wasn't enough to satisfy the actus reus for aiding and abetting. And Judge Sheen Lin looked back at some of the Nuremberg cases, and providing loans to the SS wasn't enough to make you liable as an aider and abetter. Judge Sheen Lin held that to supply a violator of the law of nations with funds, even funds that could not have been obtained but for those loans, was not sufficiently connected to the primary violation. And I think we may find that the position of the Nevsun subsidiary who's got the 60% share in this mine, may well parallel the position of the banks in the South African apartheid litigation case. So there's a problem with the actus reus. There's another fundamental problem with the corporate veil. The person being sued is the parent company in Canada, Nevsun, but it's one of its subsidiaries which has the 60% holding in the Bisha mine. It's the subsidiary who is allegedly aiding and abetting all these terrible breaches of customary international law. But we know our Salomon and Salomon, we're dealing with separate legal persons. The fact that Nevsun, the parent, may have a substantial or indeed even a total shareholding in the subsidiary doesn't mean that it is automatically going to be responsible for the wrongs of its subsidiary. We've got two separate legal people. And there may be a problem with veil piercing here. Now, you can get round veil piercing by showing that there's some direct duty of care on the part of the parent company for the activities or omissions of its overseas subsidiary. And in particular, that may be found by some real active involvement by the parent company in the particular activities of the subsidiary which have generated the claim. How much involvement did the Nevsun parent company have in the operation of the Bisha mine? We don't know. But I think this is a fundamental problem. So we shall wait and see. On the question of direct liability of parent corporations in the United Kingdom, we have a very interesting appeal which is due to come up before the Supreme Court later this month in the case of Okparby versus Royal Dutch Shell, in which this will be an important issue. Although an interesting thing about the Okparby case is that although it has been reported and it's been confirmed by the firm of solicitors who were acting for the claimants, this is a case involving land-based oil pollution in Nigeria. They've confirmed that leave to appeal has been given and that there is a hearing date set for the 23rd of June. The only slight thing which I found a bit strange is I haven't found any reference to that on the Supreme Court's website. But anyway, I'm going to be tuned in to the Supreme Court. Hopefully there'll be a video link. I imagine they can still do video links even though they'll be hearing the case by Zoom, but hopefully, if that's happening, I shall be glued to my screen on that on the 23rd of June. So that's that for now, and there will probably be another talk in the near future on the ins and outs of claims based on violations of customary international law. Thank you for your attention. Goodbye.